Hello and welcome to the third episode of our podcast series, Fireside Chats on Tech, Privacy and AI. We have started this series with the purpose of having casual one to one discussions on the ever evolving field of privacy and artificial intelligence. Today we have with us Massimo, Maltempi, and Chetandeep Singh Batra to have a fireside discussion on the topic, the future of privacy in the age of generative AI. This episode will progress in a manner whereby I will be posing a question to one of our guests and it will be open for our other guests to weigh in. I'll begin by giving a brief introduction to one of our guests before moving on to the questions, starting with Massimo. Massimo is the managing director at Lex Dynamica and MaxMal Consulting, and he is also the vice president of AI growth at Wiimer. He also serves on the advisory board at the Harvard Business Review with an impressive career that includes roles such as director at IBM and managing director at OneUp Change. Massimo has accumulated extensive experience in fields like AI, business strategy and delivery, operational excellence, risk and compliance, data protection, privacy, KYC, AML, business improvement, transformation, and change management, amongst others. Beyond his professional achievements, Massimo is deeply committed to giving back to the community. He is an active member of Lions Club International, dedicating his time to volunteering and charity work, and is also a fundraising volunteer at the Cancer Research UK. His passion for societal betterment complements his professional expertise, making him an inspiring figure both in his industry and beyond. Thank you, Massimo, for joining us today.
Thank you, Shashwat. Really appreciate it. Just a minor clarification. My role in Lex Dynamica, I'm a director. I'm not the managing director. But other than that, I mean, it's all good. No, thank you for the introduction. It's really very much appreciated.
Thank you for taking out your time. I will now move on to our next guest, Chetandeep Singh Batra, an MBA graduate from the Swiss School of Management. Chetandeep Singh Batra is a young privacy professional, New Delhi chapter, and is a senior executive privacy with one of the big fours. In addition to his numerous accomplishments in the field of privacy, Chetandeep is also a deep and ponderous person and is a published author, both in the domains of privacy and in science fiction genre. His book, Detective Avantika Cyber Adventures in Mumbai, is definitely a must read, and I'm grateful to have Chetan with us today. Chetan Deep also recently co authored the book Data is the New Oil, which, in a very innovative way, has explained various facets relating to data and privacy and how data. Being the new oil is a valuable commodity today. Thank you, Chetan, for joining us.
Thank you so much, Shashwat, for always having me here and giving an opportunity to speak on and learn about from privacy, tech, and AI. Thank you so much. Thank you, Massimo, also for coming here. Delighted to be here. I guess we can begin and start our conversation. Yes.
Definitely. So now I will begin with my first question addressed to Massimo. So, Massimo, in your opinion, what measures can companies take to adhere to GDPR strict consent requirements and CCPA's opt-out provisions when collecting and using personal data to train generative AI models?
Thank you for the question. Okay, from my point of view, there are a list of measures that companies can implement. First of all, it's really important that they have transparent data collection practices and they have a clear view and understanding of the overall data lifecycle and how the data are used by different applications, including AI models. This enables companies clearly to explain users how the data will be used, particularly for AI training. Transparency at this stage is really important and sets the right tone for trust. Then companies should definitely consider offering granular consent options. Not all users may want their data used for AI-related purposes, and that's okay. I mean, therefore, companies should allow individuals to opt in for specific uses of the data while refusing others. So, I may be open to the idea of my data being used for customer service purposes, not open to my data being used to train a generative AI model. And as a user, I need to have this freedom. And having a good, friendly interface to manage preferences ensures that all of these options, opt-in, opt-out, accept, decline, are accessible and easy to modify. Wanted to focus a little bit on robust opt-out mechanisms. Opt-out is a key cornerstone of CCPA, but also for GDPR. So the choice to opt out, to decline, must be equally visible, equally accessible to the user as the opt-in and an accept. Once the opt-out has been registered, clearly businesses must implement the right processes to respect those requests promptly. And automation can play a fundamental role here. And this involves halting the use of already collecting data for AI model development if the user opts out. It's also important that there is an effective record keeping in process in place so that proof of concept is actually well recorded, easy to find, easy to understand, and those records are really invaluable for audits. Clearly, they ensure that companies can demonstrate compliance and accountability. Alongside those measures, I mean, I do recommend also some key enabling processes and activities. Data governance processes, quickly mentioned it earlier. It needs to include periodic reviews of consent records and opt-out mechanisms, and those data sets should also be audited, to make sure that data are used or not used as consented and agreed by the end users. Some important enablers are also data minimization and purpose limitation, so that we ask consent for the bare minimum set of data that are required. Education and awareness is also important, so that both internally in the organization, but also externally, the customers, the users, really understand what their data are used for and what are the models that are being part of. Just in conclusion, I mean, I will just mention a final point. In running this exercise, it's also important for an organization to understand the role of third-party vendors and how they, do play a role in the overall supply chain. And so that's something very, very important to keep in mind in order to effectively manage and honor, the consent and opt-in and opt-out request from the users.
Thank you, Massimo. This definitely is taking care of third-party vendors is definitely quite important, in my opinion as well, because if the user or the customer has maybe withdrawn consent or opted out or not given consent, the same has to be very effectively also be communicated to the third-party vendor. Because if it is not, and the third-party vendor is not complying, then you are also in violation.
Absolutely, and this opens also, and this is probably a subject for another podcast. How we can put in place an effective supply chain management process, so that we clearly have a transparent view of what is done at by the various providers, and what are also the contracts in place and the processes that need to be adhered to, and of course audited.
Definitely. Okay, now I'll move on to the next question. This is addressed to Chetan. So, Chetan, how can organizations ensure compliance with GDPR's right to be forgotten and CCPA's right to delete when generative AI models rely on vast data sets that may include personal data?
Yeah, that's a great question, Shashwat. See, Uh, in order to answer this question, I'll firstly break it down. Okay, I will be explaining you the what is the right to be erasure or right to data deletion or forgotten is. See, in GDPR, data right under right to be forgotten provides the individual their control over the dignity of their data footprint by allowing them to delete the data which is not necessary or not required now. And in CCPA, as per, so in it is the basically for towards the California residents only. So in order to protect that data, they have the power to get their data erased from the business databases. See, these rights no are prevalent among all the laws all over the globe. I would say these rights are basically the vital that empowers the unique challenges. Now we have generative AI. The major challenge among these AI protocols is that when the data firstly is that there is a embedded data, there is a already embedded data in the modules. I would say when data is being used to train a model or a generative AI, it influences the model's behavior. This creates ambiguity whether data deletion requires restraining the entire data model or for specific purpose only. So in that specifications, we are unable to describe and figure out the what is the basic purpose of data and how it has to be dealt with. And the next point is that when we are using so much data integration when among the all the collecting from the public repositories or might be available on the website on databases, so among those aggregation of data and using to enable the learning of that module becomes very vast, and we don't know what data assets are being utilized, being used, managed, and the scalability issue trigger on. And because of those data of data right that is more on data erasure definitely hampers the person's freedom and its inability to access those rights. So in that spirit, the major domains are that these also include sensitive data also, and majorly focusing upon the challenges and the AI implications that we have. So altogether, it has to describe that when we are enabling or making a generative AI, so these rights should be enabled in all that spirit. And how this can be governed is there are I have done the four protocols to analyze that. First, that you must have a pre-designed data governance practices. So that is basically described on data privacy by design and default. So in that, we ensure that prioritize training, how data is being purposely driven, how it is to be used, how it is to be retained, how it is to be disposed of, has to be embedded into the technology to lineage so that the data lineage can be hampered, sorry, can happen and can be ingested and used in processing of that particular activity. Alongside that, we have that AI models now governing upon anonymization and pseudonymization. So uh, we can use a differential privacy techniques to anonymize or pseudonymize data because of the uh, pipeline that we have, or to blur the data points or enable them auto write given to the third parties or to the DSR management who are governing those, already highlighting with the point that Massimo highlighted. So in that integration, it has to be channelized and weight all to up both the ways, not a single way. And accordingly, now the major reason of that compliance-driven module set is that among the data elements that have been captured, some can be uh, used and isolated without any disruption to the overall system. I would be analyzing that we can use synthetic data mechanism here. We can just use the data on the pro data basis and analyze that how the patterns are working upon without actually using that data or hampering the rights of the individuals. And when we are enabling majorly when we are enabling I would say generative AI on that spirit, we have to, and in the user dashboard that we have to create a preference center in which everything should be determined, what are the rights available to the data subjects, how has to be submit their deletions, how they can submit their allow to the access of their data, how they can understand their status, or what are the current third parties being used for that application, or what are the communication channels that have preference. So in that spirit, a clear transparent notice has to go. Yeah, so altogether, the key area is that to enable the privacy by design principles uh, invested in the emerging technologies, just like machine learning or generative AI, so that it ensures the necessity into proportionality principle and align the user activities also. That's my point. Yes,
Definitely. I think privacy by design is something which for any kind of product that you're creating, where you're taking any data, it is, I think, the best practice to have.
correct,
And
correct,
especially with these AI models where you're taking such vast amount of data, and sometimes with AI models, people may not also be able to understand that how
correct.
exactly the AI is going to analyze the data. So for that, transparency is definitely important. And Chetan, you have very well put all the points. So now I will move on to the next question. This is addressed to Massimo. So Massimo, how can businesses using generative AI effectively address data subjects access requests or DSARs under GDPR and CCPA, especially if personal data has been embedded into AI models?
Okay, thank you for the question. Again, from my experience, a few points to highlight. Building on what has already been said, organizations need to have a robust data tracking and provenance system, so that they are extremely clear about the origin of the data, how the data are used, and how they are then included into AI systems. This is a journey for most organizations, especially from my experience, as some of them are kind of mapping currently their AI estate. They also need to find out. Any if there is any shadow AI activity that needs to be brought to the surface. So it's quite a busy process and a busy moment. Um, so something else also to highlight, and applies to DSARs, but also applies to the previous question around consent. There needs to be a strong and very high level of automation, because DSARs can come quite a lot, quite many, quite frequently, and data discovery needs to be done in an automatic way as opposed to manual. Once those DSARs arrive and we have the right technology and processes in place, it is really important that businesses really focus on providing meaningful responses, really addressing the question and being totally transparent, so that they can show clearly and simply how the data are used and where they're used. One key point, one of the biggest challenges, and it has been touched already a bit, is handling data deletion requests. So AI models typically don't store data in a way that allows for straightforward removal. So those AI models need to be reviewed and need to be robust, so that they can actually accommodate for data deletion. At the beginning of the generative AI journey, we were told, we cannot retrain a model. Now, clearly, from a technical and a compliance point of view, we need to make sure that data is structured in a way that can be deleted, segmented, systems and models can be retrained in the right way. Um, um, Link to that, I think it's also quite important to develop model-specific procedures. The EU AI Act gives us a lot of tips around how to document, AI models. So it's something that can be leveraged to make sure that we haven't inadvertently thrown data into a model that shouldn't have been thrown in. So those are some of the key internal enablers. I would also recommend that organizations do proactively engage with the supervisory authorities. It is a gray area at the moment. Regulations are being put in place in different countries, and so it's a new field for everyone. So clearly, to have an open dialogue with the regulators is quite important, and absolutely being proactive. If we happen to be in a situation where we are limited in our capability to, let's say, erase data, or not able to give a full answer. We need to be absolutely upfront, transparent, but also have the right remediation actions in place, because it can happen in some organizations. The AI train left the station some time ago, and we are trying to understand exactly how AI is run and managed. So those are a few points that I think could be helpful for organizations trying to address these hours.
Well, definitely, it's actually quite a lot, and I mean, with the coming of these AI models, they should, like Chetan has discussed, privacy by design. It is definitely important that from the beginning itself, the organization should be making the AI model in such a way that whatever requests come, maybe a DSAR come, or a request under right to deletion comes, they're able to actually process the request, and it does not hamper the productivity of the AI. So this definitely has to be embedded from the beginning. Really amazing points, Massimo. Thank you so
Thank you.
much.
Thank you. Thank you.
So my next question is to Chetan. So Chetan, how can the principles of data minimization under the GDPR and limited purpose use under the CCPA be applied to the training and deployment of generative AI systems?
Okay, now we are touching the depth of that purpose necessity principles. Okay, and data minimization. So, see, data minimization and limited purposes are the two core fundamental principles in global privacy. They are particularly relevant when addressing the ethical and compliant use of generative AI, which rely majorly on large data sets to deliver functionality and innovation, if I'm not wrong. So in that spirit, when we are using the generative AI system like ChatGPT or DAL AI or maybe Copilot, it it captures and identifies a vast amount of data for training and operations, but by embedding those principles into AI workflows, organization can definitely achieve their compliance while fostering trust and innovation. See, basically the importance of these principles drive upon the critical aspect because the first of all, it mitigates the risk of over collection and misuse by limiting the data collection and purpose necessity, and driving the aspects on purpose necessity principle. The organizations likely to reduce the overstepping ethical boundaries of data training or module based training, and also it reduces the exposure to data breaches or unintended misuses. The second point is that when you're labeling as these protocols are into the design or into the default mechanism or into system or to the workflow of that AI method to be used, it basically enhances the customer trust. Okay, so highlighting the similar point to what Massimo said. So in that, we have to engage the transparency with the customers. We must let them know how data is being used, how it is being managed, what are the data sets to be used in the particular purpose necessity, and how the training of the AI will happen, and what are the protocols we are using to protect those data. So in that spirit, it demonstrates a global compliance standard because see, in today's world, AI has no boundaries. See, everyone is using ChatGPT, everyone is using AI, or might be relying on some various aspects upon uh, similar tones, or see, because we are getting into the globalization of AI. So in that spirit, these AI things gives a definite challenge to commitment to the legal and ethical operations. But however, when we are enabling those protocols, this can also reduce the uh, I would say this also reduces the breaches respectability, and also increases the customer trust. So apart from those, see, when we are using the generative AI, when we know what is data is being collected, the major challenge that we is that we have we can't use the data for repurposes activities. The data collected with consent has to be determined for that particular activity only. Without we must disclose that data has to be used for training purposes, or might be used for a chatbot training, or used for a generative AI thing. So it has to rely upon that, and it has to work on that functionality only, not going beyond of it, which can cause variable damage to the organization and also hamper the rights and freedom of the data subjects. How we gonna apply those mechanisms here? The first of all, highlighting the principle based upon the Massimo the output. Transparency is the first protocol that we use. We must tell them how data is being linguistically used, how data collection has been restricted in our systems, and how we're going to dispose it off and use it. The second thing I highlighted before also, today we are utilizing these synthetic data mechanisms. Tools like data synthesizer or mostly AI can create realistic yet anonymized data, preserving utility while eliminating the privacy concerns. So in that case, we can regularly audit those synthetic data, because see, synthetic data is similar to the actual data. So we can which cannot be reversed or can be identified individuals also. It is engineering in that way. So in that spirit, we can rely upon those protocols. So, and when we are designing the infrastructure, or the, I would say, the flow of that AI, it has to be very permissively managed, how the flow is being done from collection to its disposable, and how the access control is managed, how multi-factor authentication reveals what are the encryption protocols and are being using consent, or if we can enable the use of technologies like one trust technologies or trust arc in that aspects. So yes, among those altogether principles, yes, I will give you a real life example how data has to be done. For example, if I'm designing a module for uh, research purposes based upon the identifying the diagnosis, we can identify or potentially discover for the cancer treatment. So when we are collecting data, it should be allowed for that these are the cancer treatment research we are doing, and it should be collected for that purpose only, not going that beyond purposes. And this amount of data will be collected, for example, your health data, or my phone number or email addresses, or your blood group, or any insurance data that is related to it. So that can be enhanced to train that AI. Yeah. So accordingly, altogether picture I have given, using these principles of data minimization and limited purposes, generative AI workflows, organization can maintain a balance between compliance, innovation, and ethical responsibilities. It should not be seen as a barrier, but as a boom. Okay, so it has to be constructed in that way, that these guidelines that we have for the AI, because the AI law is also here, EU Act is also here. We should have a balanced needs of technology and privacy can coexist harmoniously, and can do not hamper the freedom of the data subjects in altogether sense. Yes.
Well, definitely, Chetan. Thank you for your inputs. It is really, you have really well, in a very good and a very lucid way, explained how data minimization and limited purpose can be applied to training and deployment of generative AI systems. And well, I think your points will definitely be really educative for the audience. And now I will move on to the next question, which is addressed to Massimo. So, Massimo, how can organizations ensure transparency and accountability in automated decision-making processes involving generative AI?
Thanks for the question. I'm actually quite passionate about this topic because I come from industries that have had a tradition of automated decision-making processes, especially for large volume transactions, pre-GDPR, and they had to adapt their automated decision processing in light of GDPR, and now AI is coming to force. I think there are some key aspects to be considered. I mean, of course, we said it already a few times. There needs to be clear and accessible communication. In plain language, users need to know that AI is being used and how it is being used, let's say, to process an application for a loan or to process a claim from an insurance point of view. And clearly, users need to know who to turn to in case they have questions or concerns. Those automatic decision-making models need to be explainable. So there needs to be clear supporting documentation on how they work, and their decision-making process needs to be clearly explained. Can't have a black boxes that sort of throw outputs without really explaining. And clearly, there is also a traceability requirement so that each decision needs to be traced back to the specific input and the specific process that has been sort of developed. Human oversight and review is key. So, and organizations need to have what I would say a robust risk-based approach so that as AI models become better trained and have less bias or no bias, and they do operate correctly, then the human intervention is focused on the higher risk cases where we're not sure that AI is doing exactly in the right way. So human oversight is absolutely critical. Robust documentation, of course, is really important. I'll give you some practical examples. I mean, that kind of links back to the previous questions. In the insurance business, at least in the UK, customers whose claims have been denied or have been partially accepted, they tend to raise a DSAR in order to really see exactly how their information has been processed. So really important that we have a strong explainability model in place. Audits and assessments to make sure that those decision-making processes automated work in the right way, and there is the right level of human intervention and support and decision-making. They're also critical. This is in order to ensure ethical and regulatory compliance. On this specific topic, also would like to raise the following point. Lack of bias, appropriate ethical and compliant decision-making process. It's something that needs to be monitored over time. Data need to be collected on a regular basis. Statistical methods need to be used in order to detect even the weakest trend that goes in the wrong direction, so that the organization can intervene and correct the behavior of the models before they get out of hand. So that's something that I strongly recommend, and sort of data scientists, statisticians, can really play a fundamental role together with risk, compliance, and privacy to really ensure that automated decision models, work in an ethical and compliant way on an ongoing basis.
Well, definitely. I think it is quite important that there is transparency and accountability for AI models. It is not only for compliance, but it is also, I think, a good practice in terms of the business. So, if the business has a very open and transparent way, even the customers will, in my opinion, feel very much a lot of trust in the business. And
Absolutely.
ultimately, it would definitely increase in business. Like, for example, with the insurance. Related decisions. So if they are open, and then the customer will feel okay, yeah, so yes, they will never feel that a bad decision was taken for them. They will always feel that the company, whatever they did, it was as per their protocol and the company is there in their favor. So I really
True.
thank you for the inputs, and now I will move on to my next question addressed to Chetan. So Chetan, with the generative AI systems often operating across jurisdictions, how can businesses navigate the complexities on data transfers and regulations on data sharing?
Thank you so much for putting me on the cards. So yeah, it's again question, very important question and a very critical one also, because see, when we are doing the compliance stuff, when we are doing the readiness assessment stuff, I would be prioritizing the cross jurisdictional data transfer as a major challenge, not within the generative AI, but among the all the business atmosphere, and to harmonize the privacy frameworks in all that spirit. So yeah, see, generative AI thrives on diverse data inputs to create valuable insights and predictions. However, its global nature means that handling data transfer across jurisdiction, each with its own privacy laws and requirements. This creates a significant comprehensive challenge while adhering to GDPR, CCPA, and now we have that law in India as well, and Brazil already have that similar law to GDPR, and now the China also has that inability to give a protocol or framework to describe the data transfer mechanism. See, in GDPR, the major fact of that fact that we, apart from the appropriate safeguards, or I would say adequacy decisions, first of all, but adequacy decisions apart from the listed countries or described 19 countries, we have to rely upon SCCs. Okay, which are the standard contractual clauses, or BSR, for data transfer outside the EU. Because see, it gives the flexibility, or it gives the dynamicity to capture those data elements, and ensuring the protocols for the data transfers. And in that recent Schrems 2 judgment, it has made compliance more stringent and requires organization to access the third country privacy environment, so that the data is safe and secured and the customer trust is already put on. However, in the US, we have CCPA, CIPRA coming in, which majorly talks about consumer opt-out rights, not in data in opt-in requirements. So on that basis, when we are doing the third-party assessment, or enabling a cloud-based vendor, or using any having a vendor onboarding or third-party, so it has to be very compliant. That it carries the similar protocols that the company, the data controller is transferring to, and so that enables the proper usage and the transparency about data. And then China also, they have the most stringent responsibilities on data localization requirements that mandate sensitive data stays within China only, and they don't want to transfer it outside of the China, as per, however, exceptions are in the exceptions are there as per the protocols. In India, however, Indian law is here, but it has already described cross-border mechanism, but still it is silent upon how the rules has to be governed or has to be minimized. It has the privacy principles to be analyzed, but still I am waiting for the full-fledged law to make it more operational, and I could give a more light to it. And in the Brazil side, I already told you, based upon the GDPR thing only. See, in those designing those strategies or designing those protocols. For example, if I am sending the data from EU to might be in Bahrain, for example, see, my idea, because see, when I'm operating or my business is operating, I would be relying upon data localization principles only. I will be try my best to keep that data in the environment of EU only. See, when it goes to the third countries, now the liability directly comes on the controller, and and we have to go through the all the processes on that on requirement for the authorities, handling the inquiries or giving them the, if the data breach happens, we have to give them the timeline, we have to give them the suitable mechanism that we use to impact that data breach. But yes, altogether I would be relying upon data localization principle only, and I would vouch a vendor or third party within the sphere of that country or in that jurisdiction only. Or for example, and if, for example, if I don't have that capacity to onboard a vendor which is not in you, or which is not within the ceremony of my city or my country, or in the base in the EU, I have to rely on the third party vendor. I will be in the link that it has the same protocols being used as protocols I am using. For example, I am using encryption, tokenization, or access control are managed, or I have the multiple authentication in place, I have the IDS system, I have the passport policy. It has should have the same protocol that I am governing, and I should give them a proper do a proper agreement while data are being sent abroad. And trialing upon the protocol for the data mechanisms, I am relying on SSC to data transfer that particularly to abroad, or in PCR or certifications, or might be in the spirit of derogations. So in that spirit, I will be relying upon those, and also being saying that is there the cloud vendor using the I would say sub processor or not. So in that, I will be mapping the data anonymously, on the transparency purposes, and using the tools that I can majorly creating a preference center where I can use that how data is being controlled, managed, and being disposed of in the different world. Okay, in the different jurisdiction. So yes, uh, I will give you a practical examination. Okay, a multinational e-commerce company deploys a generative AI model to deliver personalized recommendation to customers. The model processes customer data stored in the EU, but leverages US-based infrastructure for computation. So in that, I'll be ensuring I utilize SCC to send EU data to US transfers. I'll be ensuring that all synonymization is happening in the EU data origin before it is processed in US to prevent the re-identification risks. I would be setting up a regional processor hubs in the key markets like India, Brazil to handle data locally if I had to stumble upon going cross-border sending data outside of the jurisdiction. So yes, altogether I have to make it sure that this navigation happens within the controlled sphere, not going beyond the boundaries of the governance of data. If I'm using SSC, I'm using PCR, or using any cloud vendor, or having that leverage on the privacy shield also. So yeah, these mechanism describe altogether AI adoption methodologies to stay compliant with the laws, evolving landscape, and also increasing the operational efficiency and trustworthiness in the competitive landscape. Yes, yes,
Well, yeah, definitely. When operating these generative AI systems like across jurisdictions, they it has to be ensured that proper systems are in place and everything is properly complied with. Especially when you're going through with dealing with countries where they might not have as strong laws as the one you are in. So the use of SCCs and BCRs and
correct,
other mechanisms is definitely quite important. And I
correct.
think, Chetan, you have very well put everything. And so, with this, I would like to conclude our fireside chat today. I will
Yes.
now request our guests, Massimo and Chetandeep, to give any concluding remarks they may have, or if they want to add anything further.
Yeah, thank you. from my point of view, I think it's important that as privacy practitioners, we are also monitor, how the various regulations are evolving, especially on the AI front, and what they mean for organizations, regardless of industry and size. So that's really, really quite important. And I think it's equally important to strengthen the dialogue with kind of the technology side of AI, so that there is a mutual understanding of from our side what those AI models do and how they work and how they operate, but also from a technology side, there is a clear appreciation and understanding of both the ethical and regulatory considerations that are important to use in order to use AI in a responsible way.
Correct.
Yeah, definitely. I think it is quite important. Chetandeep, now if you would want to add, like I would add something, but I wanted you to also
Uh,
have anything.
okay. I see. Okay. See, when we are using generative AI or when we are enabling the modeling or technologies in place, and actually the major challenge is that, because see, when you are creating an infrastructure or creating our own framework, or I would say AI generation, or might be something else related to it, or related to any app also, or any applications or any website also. See, uh the last point that I highlighted on the third, the question I answered is that when I have to data transfer abroad outside of the jurisdiction, see, I in the future I want to seal that even if I'm sending data to India, it should not be looked with an evil eye. Okay, it should be secured. Okay, it should be in a protected environment. So I want that. I know. See, every country has their own law now. Whether it is in yeah. So I would say in the Middle East side, now in Asia side also, it has a altogether all. We are bounded. We are not. We are. We are, I would say we are in a harmonized way of working. We have a harmonized way of working, and we can survive with the help of each other. And when we are relying on these cross-border transfer protocols now, see, it is, we have a similar law, we have, it might be different law, but if we target upon those common understandings now, we can create a altogether framework and a picture, so that this the privacy, security, the people and the audience, or might be all the people, all the globe should must have that faith on their data, that on the company, that my data with this particular company is safe, secured, whether it's in India, whether it's in I would say Dubai, whether it's in China, or whether it is in Korea. It is safe and it is secured, and I have all my rights with me to enable my, I would say, rights, or I would say my request, or it doesn't hamper my freedom eventually. So that's my idea. Yes.
Well, definitely. I think both these points are so important that, as Massimo has previously told us, that it's really important to see that whatever new laws are coming, and especially with relation to AI, we as data privacy practitioners should definitely keep an eye out for all the new upcoming laws. And as Chetan, as you have put, it is really important that the consumer trust for any business to function. It is really important that the consumer has trust in the business. If I, as a consumer, am not able to trust the business, I would not prefer working with them. And ensuring transparency, and as Massimo previously so well explained, is really important for this. And as you have so well put, that I have nothing else to add. But I really, really appreciate your inputs. And so now I would like to thank our guests for their valuable time for our chat today. I'm extremely grateful for their inputs and the great work they have done in the world of privacy. I am sure that we will have numerous opportunities to collaborate further with Chetan and Massimo for future sessions, and get massive opportunities to learn and be enlightened by them. Thank you so
Correct.
much.
Thank you.
Thank you, Massimo. Thank